My lord, I beg
Yes,
to mention item number 10, my lord. The leading counsel is out of station.
Hmm.
Therefore, this matter may be adjourned and fixed on, my lord, 6 February.
6 February.
Yes, my lord.
Learned counsel, Mr. Research, mentioning on behalf of the leading counsel for the petitioner, praise for listing the matter on 6/2/2026 as the counsel has some difficulties today. So prayer is allowed. List the matter on 6/2/2026.
My
Yes.
apologies.
May I please, Your Honor? Your Honor, I beg to mention item number 18.
Yes.
I'm for the respondent.
I'm for the petitioner.
Okay. Yes.
Since the leading counsel Deepang has personal issues, ma'am, he have left the court premises.
Hmm.
So matter may be kindly taken after 3 weeks, ma'am.
After 3 weeks.
Yes, ma'am.
Okay. No objection.
No.
Heard learned counsel, such who makes a mention on behalf of the leading counsel for the respondent, Mr. T. Panging, to list the matter after 3 weeks as the counsel has some difficulties and personal difficulties and had to leave the court premises today. The prayer is not objected to by the learned counsel for the appellant. Accordingly, list the matter after 3 weeks. Yes.
Your Honor, I have another mention, item number 20.
Hmm. Yes. This one also
Yes,
same. This one also same. Here also he is for the respondent.
yes, yes.
Learned counsel, the same ground, huh? And when do you want?
After 3 weeks,
This one also after 3 weeks. Okay, after 3 weeks. Yes.
obliged.
Achad, here, what about petitioner?
I have taken consent, ma'am.
Okay, say that the council submits, learned council submits that the consent of the petitioner has been obtained. Yes.
Obliged.
My Lordship, I beg to mention item number 19 for the adjournment on behalf of Mr. Titopu, leading counsel for the petitioner, Your Honor.
Okay.
Lordship, due to a health issue, leading counsel is out of station today. So, Lordship, matter may be fixed after 2 weeks.
Heard learned counsel, Mr. Sergeant Such, who makes a mention on behalf of the leading counsel, Mr. T. Topu, on the ground that the counsel is out of station due to some health issues, and accordingly prays for listing the matter after 3 weeks.
2 weeks,
After 2
Lordship.
weeks. Stop. List accordingly after 2 weeks. Yes.
May I, Lordship?
Hmm.
Lordship, I beg to mention item number 9.
Hmm.
I have taken consent from the other party, Lordship.
Hmm.
This matter may be listed after 2 weeks, Lordship.
After 2 weeks. Okay. Heard learned counsel, Miss MS Sergeant Such, for the petitioner, for the appellant,
No, Lordship. No.
for the respondent.
Yes,
For the
Lordship.
respondent who prays for listing the matter after
2 weeks.
After 2 weeks. On what ground?
Lordship.
On what ground?
Lordship, due to personal difficulties, conducting counsel couldn't prepare the matter.
On the ground that the conducting counsel has some personal difficulties today. Stop. The prayer is not objected to by the learned counsel for the appellant. List accordingly after 2 weeks. 2
Yes,
weeks, no?
Lordship. Obliged. And Lordship, I beg to mention item number 14.
14.
Yes, Lordship. On behalf of Legal Aid Counsel, Mr. Bagra,
Hmm.
we have also taken consent from the PP, Lordship,
When do you want?
after 2 weeks.
After 2 weeks. Item 14 also after 2 weeks on the prayer of such and such on behalf of Mr. M. Bagra, the learned legal aid counsel. Stop. Yes. Okay.
Your Lordship, Your Lordship, I beg to mention item number 15. I appear on behalf of respondent number 1. We are supposed to file a counter affidavit today, but we couldn't file the same.
So how much time do you want?
2 weeks.
Learned counsel, research and such appearing for respondent number 1 submits that he would like to file an objection affidavit in the present case and therefore prays for 2 weeks time to file the same. Stop. Learned. What about petitioner? Learned counsel for the petitioner.
Yeah, I have taken consent.
It is stated that the consent of the petitioner has been obtained. So accordingly, list after 2 weeks.
Highly obliged.
Item number 1 to 3.
May I please, Your Lordship? Lordship,
Case.
after my lord, yesterday's conclusion and the exhaustive hearing, my lord,
Yes.
there is a subsequent development, my lord.
Huh.
Charge sheet has been filed. Trial, my lord, cognizance was taken.
Hmm.
And my lord, some accused has been discharged, my lord.
Hmm.
PC Act has been removed. And the matter has been remanded back to the, my lord, the Lanit Judicial Magistrate First Class
Oh,
for taking of.
that's what I wanted to know, because if it
And-
was a PC Act case, then it should have been before the special judge.
My lord.
Hmm.
And thereafter, my lord, what happened?
Hmm.
We have, my lord, there is no material incriminating against me, my lord. None of the, my lord, the owner of these 4 farms has given, default any statement against me, my lord. My lord, the complaint, my lord, on the last occasion, yesterday also, my lord.
No, but can you produce any order to that effect? That the PC Act sections have been dropped
My lord, I'll put this.
and that it has been remanded back.
So therefore, my lord, what I prayed for
To
is,
the
my
court
lord,
of MFC.
kindly, my lord, have this matter on other day. In the meantime, my lord, the LCR of my lord, especially more particularly charge sheet. My lord, LCR is received, but that is before the filing of the charge sheet, my lord. And my lord, the one of the official whom earlier alleged has been also, my lord, discharged from the my lord, PC Act. And we have also, my lord, filed applications for discharge as because there is no material against, my lord, the.
But in that case, I'll have to release it from part third then.
My
Because-
lordship is
because-
sitting, my lord, in the next.
I'm sitting till Friday only, next Friday. And it may take time for the TCR to reach, isn't it?
It is only nearby, my lord. So therefore, my lord,
UPIA.
UPIA, my lord. If lordship having, my lord, if not convenient, my lord, lordship is not having missed any inconvenience, my lord. We can have it on.
It's not a
print,
question of inconvenience,
my lord.
but then it takes time to write the order and corrections and all that. Then
True, my lord.
if it's on the last day, then usually it creates a difficulty.
I'm sorry, my lord. This is the, my lord, the order.
Okay, we can try on Thursday.
My lord.
And if it doesn't reach, then we will release
but-
from part third, okay?
May I please, my lord? My lord, but I fail to understand, my lord, why the LCR is required, my lord.
Not
My lord-
No. They're saying the LCR which had come, the LCR which had come doesn't contain the charge sheet.
Charge sheet.
Huh.
Charge sheet, my lord, in the item number, I think, 2, my lord, where the government has filed their criminal revision, my lord.
Mm.
I have
In-
detailedly filed the
in
charge
that
sheet, my
the
lord.
charge sheet is already
Charge sheet is
there.
already there, my lord.
It's not
And my lord,
statement, other things, my lord, everything, my lord, in a full set of charge sheet is not seen, my lord.
my lord, here we are challenging the veracity of the order passed by the learned CGM, my lord.
CGM, yes.
But that is the only issue that has to be decided, my lord.
And
What
at
does
that
it?
point of time, the PC Act section was still there.
Yes, that is the only issue, my lord.
Thereafter, my lord, what happened by my lord, in the, my lord,
No, subsequent developments may be there.
yes, my lord.
That is no issue.
Why should we go to the merits of the case?
My lord,
Hmm.
another aspect is if lordship, my lord, interferes,
Hmm.
and even if it is remand back, my lord, at that time, the very fact of the case was different, my lord. Now, after the subsequent development, my lord, the charge sheet has been filed, my lord, altogether, my lord, the cognizance was taken. At that time, my lord, the matter was, my lord, decided, and even PC Act has been removed, my lord. Official of the department has been, my lord, the discharged from the, my lord, the charged. Lordship may kindly peruse, which I have documents which I have but unofficially obtained from from my client, my lord. This is the order passed on, my lord, the 21st July 2025, my lord.
Accused person's name is.
And
You are this Ngurang Ayah,
correct,
isn't it? Huh.
yes, first one. And admittedly, my lord, the contentions of the estate as well as the, my lord, the petitioner is misappropriation, madam. The misappropriation section is nowhere, madam. It is not reflected, madam. It is even not reflected in the charge sheet, madam.
Okay, okay. It was dropped only because there was no prosecution sanction
True, madam.
against the
Correct.
government official.
My lord.
That's all. But at the time when the trial court passed that impugn order, the PCI Act sections were already there.
True, madam.
Was
True.
there.
True, madam. Now, madam, the another madam aspect is, as I pointed out, madam, if lordship interfere with the impugn order, madam, the passed by the another trial court, madam. At that time, madam, even at that time, madam, the PC Act admittedly was, madam, there. However, madam, the misappropriation was not there, madam. Even in the charge sheet, it is not reflected. Nowhere, madam, it is reflected, madam.
No, but another
And-
issue is how the learned CGM took up the matter when it was a PC Act offense.
Madam, it is regarding, madam, regarding, of course, madam, PC Act will not be, madam, not applicable to me, madam. I'm the.
No, but still,
Private individual.
but still, that doesn't make a difference
No.
because since the charge sections include PC Act section, it should have been taken up by the special court, PC Act.
PC Act, madam, at that relevant point of time, madam, no, madam, the committee, madam, the designated court was constituted, madam. It was in the year of 2016, madam, when the order was passed. Designated court was not constituted, madam. In the PC Act, madam, the one designated court has to be constituted by the state government.
Yes, of course.
And moreover, madam, regarding the debriefing of the account, madam, it is only the magistrate, madam, whom, madam, the report has to be made first, madam, to the concerned magistrate.
No, but if it is a PC Act case, then the magistrate cannot take up the matter.
True, madam.
It has to be filed
But
before the.
my respectful submission is, madam, at that relevant point of time, it was not seen.
That the government will know, that the government advocate PP has to ascertain.
Yes, madam. Of late, madam, the designated court has been constituted in the state of Arunachal Pradesh, not only in respect of this PC, other, madam, the even Foksho, madam, and any other, madam, the even, madam.
2015. The order was of 2015. In 2015, designated court was not there.
Madam, so far my knowledge is concerned, madam, we have not came across and seen, madam. Earlier, randomly, madam, everything was, madam, the driving by the, madam, district and session judge and somewhere, madam, before this.
Can you please find out?
Yes, my lord, there was no any specific, I mean, now the UP has been designated as a special court for all the,
When? Recently?
not recently, my lord. But then however, my lord, in all the PCA cases, my lord, all the district and session judge were designated as the special judge.
By which notification?
At that
At that
point of,
point of
at that point of time, not the CJ, my lord. But then however, after that, my lord, only,
Show me.
only the district and session judge, UP has been designated as the special judge for the all state. There is,
At
that is
that
the reason, judge. But at that point of
For
time, my
all
lord,
the PCI cases of the state.
yes,
Yes, madam.
So where is that notification?
notification, I don't have it right now, my lord. But
You bring
then-
it tomorrow. Because that is very important.
My lord, my lord.
And another aspect, madam, another aspect, madam,
And moreover, criminal petition, again, I have also gone through criminal petition without making the informant a party.
My lord.
yes,
That is also there.
that part, yes,
That is
Okay.
miscellaneous application.
yes.
Then of course, review is there, that so that they will
Even,
cover,
even in the
review
also, madam.
covered, filed by the
Information
government.
has to
My
be
lord.
made. Madam, let us have it on, madam.
So there are many things here.
Yes, madam.
So if you can get a copy of that notification.
My lord, my lord.
Can
my
you
lord.
get it by tomorrow?
I'll try, my lord. If not tomorrow, my lord, can my lord fix it on
Tuesday,
Tuesday, my lord? Yeah.
Tuesday.
Tuesday.
When is Tuesday? Tuesday.
List the matter on Tuesday would be 27,
No, my lord, 27, I'll be out of station, my lord.
28,
28th.
28, my lord.
28,
29, my lord.
28, 28.
28, my lord.
We will not take it beyond 28.
Okay, my lord.
28/1, 2026. On which date the learned special public prosecutor shall produce a copy of the notification designating the District and Session Judge Upia as the special court for PCI cases in the
Madam.
state of Arunachal Pradesh.
We'll also try to find out the copy, my lord.
Part third, and list as part third, okay?
Item number 4.
Hey, please, my lord.
Hmm.
My lord, this is a revision petition, my lord. My lord, here the circle officer
Hmm.
who hold the executive, he is the executive magistrate of Sile Oyan, my lord.
Hmm.
My lord, here he has decided and conducted the trial of land disputes.
Hmm.
Whereas, Your Honor, my lord, kindly turn page 49.
Page 49.
Page 49 is the impugned order, my lord,
Hmm.
passed by the circle officer. May I read, my lord?
Yes.
After hearing the claim and thorough claim by the Anyup Tako and Siri, Obang Jerang and others of Mangnang village for ownership of the plot of land located at Sile Remi Korong, a spot verification conducted by Tamang Talo, PI, and right number that and Sile Oyan on 12 November 2025, along with HGB of Mangnang village and ex-secretary and youth president of Sile, to find out the actual owner. As per report be reported by neutral body, the disputed land in question belonged to Obang Jerang and others. Now the case is then disposed of and both the parties shall maintain is the utmost peace and harmony between them. My lord, here the executive magistrate has the no power, my lord. He has no jurisdiction to trial the land dispute. My lord, here already same situated matter was conducted, my lord, and decided by the learned CGM. Same location, my lord. That is, my lord, page 26. Page 26 is the judgment passed by the learned Civil Judge Senior Division Pasigat.
26.
26. And operative part, my lord, is page 38, my lord.
Page 38.
38, my lord.
Yes.
Last paragraph, my lord. It is held that there has been no violations of the principle of natural justice and there is no affirmity in the Kabang decision and which is just and reasonable. Earlier, customary Kabang was conducted and decided, my lord.
Hmm.
And now the father of the respondent was the GB who was present in the earlier spot verification.
No, this is this order, this impugned order dated 18 December 2025,
Yes,
and this order of the Civil Judge Senior Division, it pertains to the same subject
Area.
matter, same area,
same area, my lord.
and
Sile
between-
area.
between same parties.
The parties, not same parties, but the after the father of the respondent was there because Kabang was conducted.
No,
Because
so the Kabang decision dated 24/10/2017,
yes, my lord.
that had also covered this, that has also covered the plot of land
Yes, my lord.
decided by the circle officer.
Yes, my lord. That's why, my lord,
Oh.
we have submitted an application, reply before the executive magistrate that he has no jurisdiction to conduct the trial of land dispute. Already this matter was settled by the local Kabang and affirmed by the
Affirmed by the civil.
Civil Justice Senior Division. That's why, my lord, my humble prayer is that, my lord,
Okay,
this
third
the-
learned counsel, Mr. Such and Such. Your name, please give your name
yes,
for the
Tita.
petitioner. So the present application under section 115 of the CPC, read with Article 227 of the Constitution of India, has been filed, praying for quashing, setting aside of the impugned order dated 18 December 2025, passed by the
Circle officer.
circle officer,
Sile Oyan.
Sile Oyan Circle, SILLE OYA. You just see page 49 and extra F, okay? Sile Oyan. Before coming to the date, you say by the order number CO slash SO slash K dash 107 slash 2011 slash 322 dated 18 December 2025. Okay, stop. Para, the case of the petitioner is that the Kabang had taken a decision. The Kabang had taken a decision
2410.
on 24/10 to 2017. Where is that Kabang decision? Have you enclosed?
Yes, my lord.
Kabang decision dated 24/10, 2017.
Yes, space 18. Next Jerby. 18.
But where is the translated copy?
Translation copy is space 20.
Kabang decision dated 24/10, 2017, by which a decision was given with regard to ownership of of a plot of land at where is that?
Sile Oyan.
At Sile village.
Yes, my lord.
At Sile village. Stop. It is further submitted that an appeal was filed against the Kaba decision dated 24/10, 2017 before the Civil Judge Senior Division at Pasikat. Stop. And the Civil Judge Senior Division by order dated
29/6.
29/6/2023 in civil appeal number 73/2023 had upheld the Kabang decision of 24/10, 2017 with regard to the disputed plot of land. Stop. However, by the impugn order dated 18 December 2025, the circle officer, Sile Oyan Circle, has again entered into the matter and arrived at its own decision regarding the disputed plot of land. Stop. The case of the petitioner, therefore, is that the Kabang decision dated 24/10, 2017 has already been upheld by the competent civil court. By the judgment dated 29/6/2023, and therefore the circle officer, Sile Oyan Circle, had no jurisdiction to adjudicate the matter and had no power and jurisdiction to adjudicate the matter. Stop. Being aggrieved, the matter has come before this court. Stop. Issue notice, returnable within 4 weeks. Stop. The learned counsel for the petitioner shall take steps for service of notice on the respondents number 1 to 5 by inland speed document within 3 working days from today. Yes. Are you praying for any interim?
Yes, my lord. Till returnable.
Till the next returnable date, the impugn order dated 18/12/2025 shall remain suspended.
Obliged. Item number 5.
May I please proceed?
Hmm.
Proceed. This is a joint petition for passing of the criminal proceeding. Of SRPS case number 30/24 under section 329 or 324 plus 5 of BNSS.
Let's see the records first. Okay,
Lord.
we'll list it after.
My lord, I have an objection, my lord. They, although they have prayed for quashing of the criminal proceeding, but they have not challenged the order by which the criminal proceeding has been remained pending, my lord. The cognizance order has not been challenged, my lord. That has to be made as part of the record, my lord. They have only annexed FIR charge sheet. That is the part of investigation, my lord. The criminal proceeding will initiate.
Cognizance had already been taken.
Yes, my lord. They have to annex that order, my lord.
Let us see their prayer. As to why the criminal proceeding in such and such before the Learned Court of St. John may be pleased. No, but automatically when if the proceeding is quashed, everything will go.
My lord,
That-
that has been clarified by the
that-
apex court, my lord.
So go.
My lord, I will just,
Cognizance order. But that is only a procedural defect. You added, you file an IA or something.
Lordship,
Yes.
yes, my lord, because my lord, that aspect was considered by the Supreme Court as well as later on by the various High Court, my lord. Therein it has been held, my lord, so far as the investigation is concerned, my lord, it will extend to the filing of the charge sheet, which can be challenged under 226 also, my lord. But when there is a judicial order, then it has to be challenged under 528, and wherein your lordship, even the cognizance order has to be made as a part of the record, my lord.
Part of the-
Yes, my lord.
And impugned.
Yes, my lord.
Lordship, kindly, I may be
You file impugning
Yes.
the.
In the meantime, Lordship, TCR may be
Yes.
followed.
This present application under section 528 of the BNSS has been filed jointly, by the accused and the informant as petitioners, praying for quashing of the Basar case number 30, Basar PS should be, I think, isn't it?
Lordship,
Pasar PS case number 30/2024 under section 329/324 clause 5 of the BNSS, corresponding to GR number 34/2024, pending before the court of the Chief Judicial Magistrate Alo, District West Siang, Arunachal Pradesh. Stop. Learned additional PP Mr. T80 accepts notice on behalf of the respondent. Stop. Issue notice returnable within 1 week, 2 weeks.
2 weeks. Lordship.
Returnable within 2 weeks. Stop. In the meantime, the learned counsel for the petitioner is also allowed to file necessary application for bringing on record the cognizance order taken by the trial court in the present case. Stop. The registry shall also call for the trial court records and list the matter after 2 weeks.
Lordship,
Copy of trial court record, my lord.
Lordship, I have-
Scan copy
Lordship,
of
I have
trial.
interim prayer also, kindly, till next, the proceeding may.
My lord, if the impugn order is not there, then how the proceeding will be stayed, my lord?
You file the IA first, and then in the IA we'll pass the order. Okay.
Lordship, otherwise, kindly it may be lifted after 1 week.
No, when you file the IA, it will automatically
Automatically
come
stay.
up for motion.
Yes,
So the court can pass order automatically there.
Item number 6,
Lordship, if I may.
Hmm.
Lordship, if I may.
Online.
Lordship-
Okay.
Yes.
Yes.
My lord, this petition challenges 2 orders, my lord. First, the first impugn order is an order passed under section 164 BNSS by the learned executive magistrate, my lord, whereby stated for order was directed upon the disputed land. The second order is passed by the learned sessions court, my lord, whereby the order by the learned executive court was upheld, your honor. It was affirmed, my lord. My lord, the brief facts of the case is that the petitioner herein has a plot of land located at Papunala. It's around 10 square meters, my lord. Now, immediately adjacent to the petitioner's land, my lord, there was an unclaimed land. No one was there. So this petitioner, he took possession of that land and then he started constructing therein, my lord. Now, my lord will find photographs of the construction from page number 29, my lord, annexure 6, my lord.
Page 29.
Page 29, my lord,
Ah.
annexure 6, my lord. Yes.
Yes.
My lord, herein, this is the construction that was being undertaken by the petitioner, my lord. Now, the petitioner is in undisputed possession of this land since more than 1 year, my lord. And he has even constructed this structure over that plot of land, my lord. Adjacent plot of land, my lord. Now, my lord, suddenly in the month of November, the complainant hearing, the respondent number 2, he files an complaint before the learned executive magistrate alleging that the petitioner has encroached upon his land. Although he claims that that land is his, my lord, he did not provide anything to substantiate that that land is his. He provided an allotment for 2,000 square meters of land. However, his claim is that he is in possession of 4,000 square meters of land. Be that as it may, my lord, upon receiving this complaint, the learned executive magistrate issued a summon, which we have annexed at section at page number 25. In the summon, my lord, it can be seen that the magistrate, upon receiving the complaint, has initiated proceedings under section 164 of the BNSS. Now, after initiation of proceeding, the impugn order, my lord, the first impugn order at page number 19 was passed, my lord.
19.
Page number 19, my lord, annexure 1.
Yes.
Now, my lord, I would like to read out one portion of the order, my lord. One relevant portion of the order, because all the preceding paragraphs are the facts of the case, my lord. His observations start from para number 5, my lord. If I may read, my lord.
Paragraph 5,
As
yes.
far para 5, my lord. Yes, as far field verification, it was observed that Sri Techi Nikam, the petitioner herein, is in excess possession, having occupied approximately 55 meters in length, that is about 10 meters more than his purchased 45 meters. He claimed that the additional area was unclaimed land and that he occupied it up after mutual settlement understanding with neighbors and other colony dwellers. He also produced a copy of the agreement, though some witnesses have not yet signed. Now, my lord, as apparent from this order itself, Your Honor, a field verification was conducted and the learned executive magistrate found out that the petitioner is in possession of that plot of land, my lord. Now, therein, my lord, 3 directions were passed by the learned executive magistrate, my lord. In view of the facts stated above, and since the matter is civil in nature, the undersigned hereby directs as follows. Both parties shall approach the appropriate civil court for redressal of their grievances. Second, status quo shall be maintained. Neither party shall construct or erect any structure on the subject land measuring 14 square meter RCC retaining wall into 6 meters up to 2 pillars from the RCC retaining wall equals approx 84 square meters until final disposal of the matter by the competent civil court. Now, my lord, this order was challenged before the learned in a criminal revision before the learned session court, my lord. However, the session court did not find any infirmity in this order, saying that the petitioner was found to be in possession of encroached land, therefore the revision is not maintainable, and there is that reasoning was given, my lord. Now, my lord, the petitioner is aggrieved, my lord, because section 164 BNSS, my lord, it categorically states that if I may read, my lord, the relevant portion, if I may, my lord. Subsection 4 of 164, subsection 4 of section 64, my lord. The magistrate shall, without reference to the merits or the claims of any parties to a right to possess the subject of dispute, peruse the statements so put in, hear the parties, receive all such evidence as may be produced by them, take such further evidence, if any, as he thinks necessary, and if possible, decide whether any or and which of the parties was, at the date of the order made by him under subsection 1, in possession of the subject of dispute, my lord. This is the mandate of section 164, my lord, that the factum of possession is to be determined by the magistrate. As my lord may kindly observe that it says that without reference to the merits of the claims of any parties to right to possess the subject of dispute. Now, The magistrate does not have to go into the merits that who is entitled or who deserves to possess that land. He has to determine who at the point when the proceedings were initiated was in possession of the plot of land, my lord. And as apparent from the photographs, as can be seen from the photographs, my lord, that the petitioner was undisputedly in possession of the plot of land. Now, even the impugn order, as paragraph number 5, it says that the petitioner is in possession of the plot of land, my lord. And even the status quo order, my lord. The status quo order is given for the portion at page number 29 itself, my lord. The protection come retaining wall and the pillars. Now, that portion wherein the petitioner is already in possession and is undertaking construction, that portion has been kept under status quo by the learned executive magistrate, my lord. Further, my lord, if I may, subsection 6, my lord, it is the petitioner's submission ground that the status quo order is also in derogation of subsection 6 of section 164, my lord. If I may read, my lord.
Yes.
164 subsection 6, it says A, if the magistrate decides that one of the parties was or should, under the proviso of subsection 4, be treated as being in possession of the said subject of dispute, he shall issue an order declaring such party to be entitled to possession thereof until evicted therefrom in due course of land, and forbidding all disturbances of such possession until such eviction. And when he proceeds under the proviso to subsection 4, may restore to possession the party forcefully and wrongfully dispossessed. Now, there is no allegation of this forceful or wrongful disposition in this case, Now, undisputedly, my lord, the plot of land was in possession of the petitioner, my lord. Therefore, my lord, instead of protecting the petitioner and directing the respondent number 2 to approach the appropriate civil court for redressal of his grievances, and status quo order has been passed against my possession itself, my lord, against the mandate of section 164 subsection 6, my lord. Now, my lord, why we are praying for quashing this impugn order is that because, my lord, if my lord will see section 20, this page number 29, my lord, this retaining wall has not been completed, my lord. And from the pictures itself, my lord, it is apparent that at page number 31, my lord can see the area is as such, the terrain is as such that, my lord, it is susceptible to natural calamities, my lord. Rain, rocks falling, mudslide, landslides are quite common in this area, my lord. It can happen. And if the rain starts, then, my lord, the petitioner's whole building, which is downwards, as apparent from the these photographs, my lord, would be in danger, my lord. So our submission was that, my lord, since the magistrate
You have filed this application under 528.
Yes, my lord.
Section 528.
Yes, my lord. For quashing for setting aside two impugn orders, my lord.
The order of the session judge is a final order, isn't it?
Yes, my lord. It was
Yes, my lord.
Finally disposed of.
Yes, my lord.
Yes, my lord. This is a criminal petition. However, my lord, in this case, my lord, the private respondent is there. Because it's a dispute between the two parties, my lord.
Yes.
And perhaps there was a likelihood of a breach of public peace and tranquility. So the learned magistrate has initiated the proceeding under 145 corresponding to 164 of BNSS, my lord. However, my lord, it's a prima facie, my lord. It seems like, my lord, the learned magistrate has assumed the power of civil court and exceed his jurisdiction, because, my lord, here under this provision 164 and 145, my lord, the magistrate has to decide only the factum of possession.
It is very limited, actually.
Yes, very limited, my lord. Only possession, whether it is legally or illegally, that is immaterial, my lord. Only has to decide who is in the possession except that proviso is there, my lord. If somebody has been dispossessed within 2 months before the initiation of this 145 proceeding, or after initiation, before the passing of the conditional order, if somebody dispossessed, then, my lord, the order of eviction can be passed. However, in this case,
Otherwise, the magistrate has
only to decide the possession.
observed that the petitioner was in possession.
Yes, absolutely. And then he exceeded,
And
my lord.
then after that.
Yes, he has committed an error, mistake. And that has been, my lord, upheld by the session court, my lord, in revision, my lord. That itself is not correct, my lord. So at this stage, my lord,
At this stage, we'll issue notice.
yes, my lord, and
Yes,
the
because respondent 2 is also there.
yes, my lord.
Learned counsel for the petitioner, Shri, your name? Such and such.
My lord, G Talo,
Name?
my lord.
Di Talo.
G Talo, my lord. My lord,
Di
we also had
Talo.
a
So,
G Talo. My lord, we also had
G
a
Talo.
prayer for interim, my lord.
wait, let that be considered on the next date after
My lord,
the respondent 2 enters appearance. Okay.
my lord, our interim prayer is
the-
very limited, my lord. Actually, my lord, as I have shown in the photographs, my lord, the construction has been stopped, my lord. And now, my lord, till the appearance of the opposite party, my lord, it is not known how and when they will come, my lord. So our only limited prayer was that we may be allowed to at least finish the retaining wall, my lord, our construction of the retaining wall, my lord, so that before the rainy season starts, my lord, at least we will be protected. Afterwards, my lord, if any order is this passed, my lord, that be so, my lord. But if we are not protected, my lord, and if the rainy season starts, my lord, the whole building will be in danger, my lord. Only for limited purpose of construction of that retaining wall, my lord. That interim prayer only in that regard, my lord.
Okay,
Limited.
we'll see. Stop this application, this application has been filed under section 528 of the BNSS, praying for a direction to quash the impugned order dated 28/11/2025, passed under section 165 of the BNSS by the learned extra assistant commissioner cum executive magistrate Nahar Lagun in NLG/AC/estate -01/2025. Stop. Further, the petitioner has also assailed the order dated 19/1/2026, passed by the Learned Sessions Court UPIA in criminal revision petition number 3/2026, whereby the petitioner's application praying for setting aside the order dated 28/11/2025 was rejected. Stop. Para. Issue notice returnable within 4 weeks. The learned additional PP, Mr. T. Ete, has accepted notice on behalf of the respondent number 1. Hence, no further formal notice needs to be issued. Stop. The petitioner shall take steps for service of notice on the respondent number 2 by inland split document within 3 working days from today. Stop. Para. This is the matter after 4 weeks. Stop. In the interim, it is directed that where is your prayer? Let's see your prayer.
My lord, page number 16, my lord.
In interim, the impugned order, orders dated 28/11/2025 and the impugned orders dated 28/11/25 passed by the learned extra assistant commissioner cum executive magistrate Nahar Lagun and 19/9/2026 issued by the learned sessions court UPIA shall remain suspended till the next returnable date. Stop. As the interim order is passed in the absence of the respondent number 2, the respondent 2 is at liberty to approach this court for modification/alteration of the interim order if so advised. Is
Obliged, ma'am.
Much obliged, my lord.
Item number 7.
Lordship, pass over for time being, Lordship. That in this council is omelette.
okay. Pass over for the time being.
No time.
Item number 8.
Little lots. Recent criminal petition under section 528 challenging the impugned order dated 23rd
6/2025 passed by the Launch Special Judge NDPS UP Papumpari district in NDPS case number 31/2020 arising out of under the case number 101 of the 2020 under section 21B of NDPS Act, whereby the bail granted to the accused person was cancelled and the bail has been discharged by the Honorable Court Lordship. Height order dated 23rd/6. Annex page number 15, Lordship. 15 and 16. Violation of bail bond condition, the bail bond was rejected by the Honorable Court Lordship, Line Trial Court Lordship, without notice. Page 16. 15, 16.
Your Lordship, bail condition was violated, Lordship.
We will call for the records, but before cancellation, notice has to be given.
Yes,
Yes,
Lordship.
Your Lordship.
But no notice
The
has issued.
present application under section 528 of the BNSS has been filed by the petitioner assailing the impugned order dated 23/6/2025 passed by the learned special judge NDPS Upia, Papumpari district in NDPS case number 31/2022 arising out of Bandar Dewa PS case number 01/2020 under section 21B of the NDPS Act, by which the bail granted to the accused was cancelled and the bailer was discharged and the accused was taken into custody without and it is alleged that the impugned order dated 23/6/2025 was passed without issuing any notice to the accused person and without giving him an opportunity of being heard. Stop. Issue notice returnable within 4 weeks. Stop. The learned additional public prosecutor MSL Hagi accepts notice on behalf of the state respondent. So the registry is directed to call for the
Teacher.
This scan copy of it is here.
scan copy of the trial court records from the court
27
concerned.
and
Stop. List
27.
after 4 weeks. Yes.
Next that
4 weeks.
the trial is going on, Lordship. 27, yeah, 29.
Trial is going on.
Yeah,
Okay, 2 weeks. After 2 weeks.
1 week.
No.
27, yeah, 29.
No. That cannot be. 2 weeks. Notice returnable within 2 weeks.
Oh, bless it.
Right, Lordship.
Item number 11.
My lord, this is this petition
Hmm.
is for cancellation of the regular bail, my lord, granted to the respondent number 2, my lord, who is also a senior IS officer, in a case of abatement of suicide, my lord, where the deceased left 4 handwritten suicide notes expressly naming, my lord, the respondent and other officers, my lord, other officers, my lord. Now, the SIT, my lord, the special court, granted the bail within 5 days, of the arrest, despite SIT's strict oppositions, my lord, and also, my lord, despite the investigation was at the initial nascent stage, my lord. With critical mobile data, WhatsApp chats, voice messages pending forensic extractions, my lord. My lord, now
You are, who are you? You are the informant.
Yes, my lord. I am the complainant, my lord,
Complainant.
and I'm also the father of the deceased, my lord.
Okay.
The father of the deceased, my lord. So I am the victim, my lord. The victim. So after post 2019, my lord, I have the every rights, my lord, to come for a fair hearing, my lord. Lord, my lord, cancellation, my lord, just before I come to the facts and also to the lord, to the law, my lord. I would like to state, my lord, cancellation is not reappreciation of the merits, my lord, but rather it lies where, my lord, the bail is perverse, premature, or likely to thwart investigation, my lord.
And in this case, my lord, these three ingredients, my lord, is very much present, my lord. Now, my lord, I will just take my lord to,
Let us see the bail order.
yes, my lord.
Page.
My lord, the bail order is page 14. That's annexure 1, page 14, ma'am. It will be relevant to refer from paragraph 5, my lord. Paragraph 5, because that's the submissions of the SIT, my lord. Paragraph 5 of the bail order, my lord. If my lord has got, may I read? It is submitted by the learned additional SPP appearing for SIT that the present case is initially registered as UD case in and thereafter regular case by Nirjuli PS case number so and so under section 108 to 71, 272 of the BNS is registered. The case is handed over to SIT for investigation only before 6 days, and as SIT has already started its investigation and interrogated the accused at judicial custody after taking permission from the court. It is submitted that the accused person has given different dates since when he was in contact with the disease, as the CDRs and other materials does not support his depositions. It is submitted that the accused person used different phone numbers and the SIT needs some more time for collecting the CDRs and of the said phone numbers used by the accused person. It is submitted that there was several WhatsApp chats and voice message exchanges between the accused and the deceased, but the said chats were deleted from the mobile of the accused and deceased, and accordingly, SIT has forwarded mobile handsets of the accused and deceased for FSL examination for retrieving the deleted WhatsApp chats and voice messages. It is submitted that there are incidents even when voice messages were sent from toilet and the same was deleted before coming out from the toilet. It is submitted that the investigation of the case is still at initial stage and releasing of accused person may result in hamper and tamper with the investigation, as the accused is not a layman but an IAS officer, and there is every possibility that his release on bail may hamper investigation of the case. It is prayed that the accused person may not be released on bail at this initial stage of investigation, my lord. Now, paragraph 6 is a submissions of the complainant, my lord, represented or with the permission. We can skip this, my lord. And paragraph 7, my lord. Paragraph 7, the investigation agency has produced a case diary as called for. Learned additional SPP has marked the relevant portion of the case diary to be considered by this court. I have carefully perused the case diary produced by the investigating agency. It is seen that the IO has visited the PO, conducted inquest and post-mortem examination of the dead body and recovered 4 pages suicide note, 1 iPhone and detailment orders in respect of late so-and-so along with personal documents. The PME report shows that the deceased died due to asphyxia resulting from hanging and suicidal in nature. It is also found from the case diary that one of the accused persons in suicidal note, namely so-and-so, has committed suicide by shooting himself. Accused so-and-so has surrendered and thereafter he was remanded in judicial custody, and on medical examination he is found to be HIV negative. Requisition have been sent to various bank accounts for obtaining detailed statement of deceased late so-and-so, and so-and-so. CDRs in respect of deceased so-and-so and has been requisitioned. Requisition has been placed to the DC Itanagar for report on the engagement of late so-and-so in their office and camp office and activities during the period of 24 and 25. Signature and handwriting specimen of arrested accused is obtained, and even admitted handwriting of the deceased so-and-so is also collected. Report has been obtained that deceased so-and-so was detected to be infected with HIV on 08/12/2023, and he was under medication since 15 December 2023. It is commented by the investigating agency that the arrested accused is one of the persons named in the suicide note left by the deceased. It is found that the accused person has engaged.
Continue at 2.
My lord, at 2, my lord.
Yes. Continue, yeah.
Before the recess, my lord,
Hmm.
we are reading the judgment, the impugned judgment order, my lord.
Yes.
Now, paragraph 8, my lord. I'll start from paragraph 8.
Hmm.
It is commented by the investigating agency that the arrested accused is one of the persons named in the suicide note left by the deceased. It is found that the accused person has engaged the accused in various law and order duties without any formal appointment orders. One of the mobile handset of accused has been seized, while other mobiles which were being used by him are yet to be seized. Several other witnesses acquainted with the case are yet to be examined. Various bank accounts details and CDR's reports have been requisitioned regarding deceased late so and late so as well as so for calls and transactions between them. The analysis required detailed scrutiny. It is submitted by the IO Inspector A. Tayeng that since the case is serious in nature and in its nascent stage, further sustained custodial detention may be required. There will be checking, cross-checking, and verifying much facts and figures to reach a conclusive end. Many more witnesses are yet to be examined. If released, the accused may hamper with the witnesses or investigation. It is prayed by the IO that the bail application may be rejected at this stage. Before considering the materials placed before this court, we have examined the law for the time being in force. Earlier, as provided under Section 309, an attempt to commit suicide considered to be an offense. Said offense of attempt to suicide is decriminalized after enactment of Mental Health Act 2017. Now, on enactment of BNS, suicide or attempt to suicide does not consider to be an offense. However, there is no doubt that such an act of suicide clearly reveals unbalanced mental health of the deceased. My lord, I'll just pause for a moment, my lord. While passing, my lord, the bail applications, my lord, and without appreciating under what circumstances the young man has taken his life, my lord, and without any authority, my lord, without expert authority, my lord, the learned court has erred in law in declaring, my lord, in this bail order that the accused, the deceased, suffered from unbalanced mental health just because he took his own life, my lord. So this is one occasions giving a premium to the accused person, and this is going to influence and unfairly affect the investigation at the later stage, my lord, and also the trial. Therefore, the fairness in the investigation and a trial itself has been curtailed in the first instance itself, my lord. So I'll just
Please continue.
Yes, my lord. So paragraph 10 now, my lord, paragraph 10 of the impugned judgment. In present case, allegation against accused so-and-so is for commission of offense under section 108, 271, 272 of the BNS. Section 271 of it provides that whoever unlawful or negligent does any act which is and which he knows or has reason to believe to be likely to spread infection of any disease dangerous to life shall be punished with imprisonment of either description for a term which may extend to 6 months or with fine or with both. Further, section 272 of the BNS provides that whoever malignantly does any act which is and which he knows or has reason to believe to be likely to spread the infection of any disease dangerous to life shall be punishable with imprisonment of either description for a term which may extend to 2 years or with fine or with both. In present case, it is alleged that the deceased had illicit relationship with the accused and led so-and-so, for which the deceased was infected with HIV positive. Seen the record, including case diary, and found that as per electronic surveillance, accused so-and-so found to be in contact with disease so-and-so since January 2025. It is observed that from the case diary, that late so-and-so was found to be HIV positive since 08/12/2023, and he was under medication since 15 December 2023. above materials clearly shows that disease so-and-so was infected with HIV positive much before a year when he met accused so-and-so. It is observed that an offense under section 271 and 272 of the BNS are not attracted against accused so-and-so as he is found infected as he is not found infected with HIV positive, and there is no possibility that he has spread such so-and-so before meeting the accused. It is also found that the accused was born on 23/06/2005, and at the time of the death, he was more than 20 years. And when he first met the accused, so-and-so was more than 19 years of age, so there is no question of attracting section under POCSO Act against the accused so-and-so. It is further observed from record the deceased has written 4 pages suicide note wherein he has allegedly accused so-and-so and so responsible for his commission of his suicide. It is observed that deceased allegedly met on a gay dating apps, namely Blued, and thereafter they got to know one another and had intimate relationships. Such a disclosure by the deceased clearly shows that he was a member of the gay dating apps through which he came to contact with so-and-so, and the action of that shows that he voluntarily indulged in illicit relationship. The allegation in the suicide note is that the disease is in fact with HIV positive from amount of rupees 1 crore and later on denied, and now he is writing the suicide note before his death to seek injustice. Now, my lord, page, para 12, the allegation as per suicide note against so-and-so is that if the disease was not received in the post, he would not commit suicide. Because of so-and-so, he did those things and there is no way left of living. He was peacefully studying in college with better life, as people are thinking that they know they met, that how they met. He met so-and-so in FB, after that on WhatsApp, and had an affair. He then recruited him in the post. The deceased would request CBI to investigate, and he has many black money and illegal properties. So, my lord, the suicide note is saying about a sexual favor, my lord, of a young boy. Taking he has been taken advantage of, my lord, being a young student, my lord, also here. The allegation in the present case is that the accused so-and-so is responsible for the death of the deceased as he insists the deceased to do the job. Seeing that the engagement orders issued by accused so-and-so clearly shows that deceased so-and-so was engaged for carrying out patrolling at Itanagar Capital Region for preventing all kinds of illegal earth cutting, illegal dumping of debris on our right-of-way, river, drains, illegal construction. It is alleged that such engagement orders were issued by so-and-so by misusing his official capacity. Observe that such an appointment of illegal orders or unauthorized engagement orders may be misuse of official capacity, which may attract service law and not a criminal offense. Even though there is an allegation of possessing black money and illegal property, such allegation may be attributed on offense under PC Act, and the same cannot be considered to be an offense or abetment to suicide. So, my lord, 14 and 15 we can skip for a moment, my lord, and we'll come to 16, my lord. 16. It is, my lord has got. It is observed that the suicide note written by the deceased so-and-so that accused is responsible for his suicide, as so-and-so has insisted him to do that job, he would not have suffered this without so who has given him the job as he had affair with the disease. It is seen from the records of the case that except the allegation that the accused person has engaged the disease for performing some job, there is no allegation in the record that the accused person has by any means abetted or instigated the disease for commission of suicide. The act of abetment must be exclusively demonstrated through action or behavior of the accused that directly contributed to the victim's decision to take his own life. However, the materials in case record does not clearly reveal that it is the accused person who has abetted the suicide of disease. Rather, the case record shows that it was the deceased who has forwarded message to his wife alleging that he has not taken the name of before police, and if does not help him in the case, he would speak out the same to police. The above materials of case record shows that it was the deceased who was persuading the accused and his wife for help and assistance. Though this court, while considering the application of bail, is not to consider the merits of the case, but what we need to examine the case records to find out prima facie offense for which the accused person is arrested and detained in custody. The allegation in the present case, it reveals from the case record, is regarding the misuse of official capacity by accused so-and-so while engaging the disease, but such a misuse of official capacity cannot be termed as offense of abetment of suicide as defined under section 108. Accordingly, my lord, the bail was granted, my lord. Now, my lord, the perversity part of this order, my lord, is, of course, the learned special judge himself says that the merit of the case need not be touched. But whatever paragraphs that I have read it to my lord, in my humble submissions, it's very much has touched the merits of the case, not only finding whether there was a prima facie or not, my lord. And above that, my lord, when the investigation is at its nascent stage, the police are still investigating, the police are yet to record, extract the data, CDR data, WhatsApp, the handwriting experts reports, forensic reports. And the allegations, my lord, is a very serious in nature, my lord. The allegations is of abetment of a young man to commit suicide. And this young man very clearly says that I committed suicide is because of you. And this is a dying declaration. And this qualifies to a dying declaration. My lord, I will take to my lord to the suicide notes.
It's 24.
Page, my lord, 24. Page 24 is a suicide note, my lord. And this is a handwritten. At this point of time, the forensic report has yet to come, my lord, to ascertain whether this young boy who was taking his life, taking an extreme step, has really written or not, my lord. Now, the type copy is at page 25. Now it says, my lord, the reason of my death is Shri so-and-so. If he didn't recruit me in the post, I wouldn't die now or commit suicide. Because of him, I did those things and there's no way left of living. I was peacefully studying in college with a better life, as people are thinking that how we met. We meet in FB. After that, WhatsApp, he has an affair with me. He then recruit me that post. I would request CBI to investigate him. He has many black money and illegal properties. So we'll not read the second part because second part, my lord, he was also co-accused who has taken his life immediately. So and there is also, my lord, as I've said, my lord, there are 4 suicide notes, my lord. And the second suicide, my lord, which was found is page 28 also, my lord. That's annexure 2 in series, my lord. And the type copy, again, he reiterates here, page 29, my lord may see, page 29. Here again, he reiterates by saying, my lord, the reason of my death cost will be responsible so-and-so. I have to commit suicide because of him. If he does not insist me to do that job, I never have to suffer this because of him. He even have affair with me because of that. He had given me that job. He need to compensate everything an amount that I have to pay. Direct allegations, my lord. And this is declaration, my lord. And after writing this, the young man took his life. So this qualifies to be a dying declaration. Now, in the teeth of this dying declaration, my lord, what did the impugned judgment say? This boy was suffering for a mental disability. And my lord will, my lord, kindly look at the FIR also, my lord. Page 30 is the FIR which has been filed by me, my lord.
Page 30.
My lord, that's a page 30, my lord.
Yes.
Just give me the type copy. Is it?
Inviting reference.
My lord, page 33 is the type copy, my lord. That's more legible, my lord. Page 33. My lord has got page 33, my lord.
Yes.
Yes. May I read, my lord, the page 33?
Please read.
To the officer in charge, Nirjuli Police Station, District Papumpare, Arunachal. Subject: FIR regarding the abatement of suicide, mental harassment, corruption, sexual exploitation, and deliberate endangerment of public health by Sri so-and-so, Special Secretary PWD New Delhi and so-and-so. Sir, inviting reference to cited subject above, the undersigned is making this entreaty to bring on record and respectfully submit this FIR for your immediate and urgent intervention in connection with the tragic death of so-and-so, now deceased, who took his own life at around 11 a.m. on 23/10/2025 at his rented house in Lekhi village, after being subjected to unbearable mental torture, humiliation, and coercion by certain senior public officials. A suicide note recovered from the deceased categorically named so-and-so, who is posted at Delhi as a Special Secretary PWD, and so-and-so Executive Engineer RWD, who is present posted at Chiang Tajo, as the persons responsible for driving him to brink of despair and ultimately to death. The deceased, in his final words, has detailed the series of mental harassment, threats, and intimidation inflicted upon him by the aforesaid officers. He stated that he was relentlessly pressured to engage in corrupt practices and to extend illegal labors in matters relating to departmental works and funds by so-and-so, who has later appointed him as MTS on contractual basis, and to act on his behest for execution of illegal works. Thereafter, it has also been alleged that the said alleged accused person has sexually exploited him by engaging in homosexual activities. On many occasions, the deceased has refused to comply. However, he was deliberately targeted, humiliated, and mentally tortured through continuous harassment and abuse of authority. Thus, having no alternative, he has acted on the whims and caprices of the alleged accused. Such unlawful conduct of the accused public servants caused extreme psychological distress to deceased, depriving him of peace of mind and leading to his tragic end. Be that as it may, the suicide note further discloses shocking and heinous allegations that the accused officer, executive engineer, was also involved in sexual exploitation by forcefully keeping homosexual relationship with the deceased. Further, it also depicts that the alleged accused, who is presently working as executive engineer, has also offered a sum of rupees 1 lakh to have a physical intimacy since he was gay and has maintained a distance with his wife for a long time. The note also certain specific reference to act which indicates deliberate inflicting of HIV to the disease by the alleged accused, having conscious of the fact that the alleged accused is suffering from HIV positive and export. So this part we can do because it's, yes, it has to the other person, my lord. It is therefore, my lord, it is therefore earnestly requested that this complaint be treated as an FIR and a case be immediately registered against so-and-so, my lord. So accordingly, my lord, the FIR came to be registered, my lord. So my lord, the grounds, before I take to few citations, my lord, in support of the contentions, my lord.
I need not tell you that cancellation of bail is not very easy, and
Yes,
unless
of course.
very cogent
Yes.
and overwhelming circumstances are made out,
Yes.
this court
Yes.
would not like to interfere.
My lord, I quite follow that, my lord.
Because, okay, the learned trial court has discussed the merit.
Yes.
Initially, that all that is discussed, but then finally, the ground is the findings of his order is given in paragraphs 17 and 18. So the finding is that arrest and detention should not be a punishment,
Yes.
and that he is an officer and a government official, and therefore no possibility that he will evade the trial.
Yes.
So those are the main reasons why the bail has been granted.
My lord, may I take my lord to one of the judgment just to answer to what my lords are saying, that because my lord is in the case of this no, that Darshan's case. My lord, I'll just forward this to the court master, my lord. Because my lord has correctly taken the cancellation of bail, my lord, under what circumstances it can't be or it cannot be, my lord. So the cancellation of bail, my lord, in this case, paragraph 18, my lord, may kindly see paragraph 18. Paragraph 18b, cancellation of bail, my lord.
Yes.
The Supreme Court has held while dealing with the law of cancellation of bail in this case, my lord. As per, my lord has got 18b cancellation bail, 18 point, yes, ma'am. As per Halsbury laws of England, the ground of bail does not set the accused at liberty in the absolute sense, but merely shifts custody from the state to the sureties. Consequently, cancellation of bail entails an assessment of whether the accused has abused liberty so conferred. 18.11, my lord, in Dolat Ram versus this court delineated broad, though not exhaustive, grounds justifying cancellation of bail, including interference or attempt to interfere with the due course of evasion of the abuse of the concession of bail, likelihood of the accused fleeing from justice. Now, my lord, next, in Abdul Basit, this court elaborated the circumstances in which bail granted under section 439 may be cancelled, including where the accused engages in similar temper, and all this talks about the post bail conducts, my lord. Because I am before my lord is the perversity of the order itself, which I've said from the beginning. Two things, my lord: the perversity and the immature, and not looking into the graveness of the allegations, my lord. On this point, these two. So, my lord, will further read this one.
So you're not under post bail?
No, I am not under post bail because, my lord, now the situation does not change. If at the first instance, if the bail was perverse, as I've said, the three criteria that I've set out, my lord, if my lord is convinced on those three by reading, then the post conditions is immaterial because once it's a perverse and it's a perverse, it has to go in any way. So therefore, I am on that point, my lord. So, my lord, in 18.13, my lord. In Mahipal versus Rajesh Kumar Supra, Justice D.Y. Chandrachud explained, an appellate court is empowered to set aside a bail order if it is found to be based on misapplication of legal principles or where relevant considerations have been ignored. On the other hand, cancellation of bail typically arises from post-bail conduct or supervening circumstances. Finally, 18.14, finally, in Deepak Yadav versus State of UP, this court reaffirmed that bail already granted should not be cancelled in a routine or mechanical manner. Only cogent and overwhelming circumstances which threatens the fairness of the trial of the interest would warrant such interference. Thus, it is clear that while cancellation of bail is a serious matter involving deprivation of personal liberty, the law does not
The law does permit.
Oh, so I'm sorry. The law does permit annulment of a bail order that is unjustified, legally untenable, or passed without due regard to material consideration. The distinction between annulment of bail orders due to perversity and cancellation for post-bail misconduct must be clearly understood and applied, ensuring a careful, calibrated, and constitutional sound approach to the administration of criminal justice, my lord. So my lord has seen when I have read out to my lord, the main materials before the court, before the police, was the suicide note. Had the suicide note not been there, my lord, it could have been a natural death. But the suicide note was there, my lord. Now the suicide note has been discredited. The suicide note has been discredited in a bail order, my lord. And how the suicide note got discredited? By calling the person who has taken his life as mentally disturbed or mentally disabled. So where is, I asked the question to myself, so where is the fairness in the entire thing? Now, this order is certainly going to influence the investigation and certainly going to influence the fair trial of the case subsequently, my lord, if the case is charge sheeted. So then where is the fairness in the criminal trial in this matter, in this way? So that is where I keep on saying, my lord, this is a perverse order. You may have given bail later on subsequently when enough evidence is taken out, but not at the nascent stage, when the SIT is still conducting the investigation, my lord. And my lord, another bail rule is that the person who arrested, the person should not be in a position to influence the witnesses, influence the temper of the evidences, my lord. Here we are not dealing with an ordinary man, my lord. We are dealing with somebody who is access to all the Molo missionaries. With due respect, I say that. So therefore, my lord, these vital aspects have not been considered, which are out to be considered while granting a bail, my lord. That is the rule. So, my lord, further, my lord, why Mary should not be touched, my lord?
Before being released by this order dated 4/11,
Yes, my lord.
how long was he in custody?
My lord, I'll just come back, my lord. When just take a minute to come back, just give us a little background of how did it happen, my lord. When this boy committed a suicide, and it was all over the news, my lord, all over the news, and the suicide notes came out, and it was all over the social media and all the medias, print, electronics, everywhere. This gentleman was posted in New Delhi. He went on hiding. The other gentleman took his own life by shooting from his own licensed gun, my lord. Thereafter, my lord, out of nowhere, one day he popped up before the police. He went and surrendered himself. At that relevant point of time, my lord, SIT lawyers will be able to justify why they have not taken the custody. They could have taken the police custody. Straight away, they said, give it the judicial custody. The first day itself, my lord, what I believe, my lord, once an accused is an accused, no matter whether you are a small accused, you are a big accused, once an accused is an accused, you should be treated the same. Subsequently,
police never took his custody.
Police never took the custody, my lord. So that is the reason why, my lord, as a father, my lord, as a family, as a victim, my lord, I am coming before my lord, pleading, my lord, let some truth come out. Why are they trying to curtain right from day one? As a family, my lord, and this impacts the social. Why are they so interested to curtail everything at the hush up and brush everything under the carpet from the first day, my lord? And why was, my lord, in all other cases, my lord, I'm not, by saying this, I'm not questioning the dignity of the learned special judge, my lord. Why this case, my lord, 6 days? And the allegation is such heinous, my lord. A young boy committing suicide. And direct blame was on somebody. A named person, my lord. So, my lord was asking a question, how long he was in custody? He was in custody for 6 days. 6 days, not even 1 week, my lord. 6 days, what could have they investigated? My lord, para 20 of this judgment itself, when we talk about the merit, my lord, I'm coming back to that. Para 20.2, my lord. My lord has got
Para 20.
20.2, my lord. There's a bold, my lord, where it's written, courts not expected to render findings on merits of the case at a bail stage.
Oh, okay.
My lord has got.
Yes.
May I read, my lord? It is a settled principle that at a bail stage, courts are not precluded from undertaking a detailed examination evidence.
Are precluded.
Oh, I'm sorry. Courts are precluded from undertaking a detailed examination of evidence or rendering findings that such upon the merits of the case. Only a prima facie assessment of the material is warranted. The court cannot conduct a mini trial or record conclusions that could influence the outcome of the trial, my lord. This is what I fear the most, my lord. My lord may have seen down there, my lord, after discussing all the details, came down to say that, oh, there is prima facie or there's no prima facie, therefore I'm giving you a bail. But what about the observations that was made in the above paragraphs? Give me that one. So there is another judgment, my lord. Pawan Kumar, my lord. My lord, I would like to refer to the case of Pawan Kumar, Puran also. No, this not this one. Pawan Kumar.
But why the prosecution does not have any grievance?
I'm sorry, my lord. That it is for them to answer, my lord. Because from the reading of the bail order, my lord, I have pointed out, my lord, not to reiterate myself again and again, my lord. I have pointed out how it is perverse, my lord.
Yes, the other case.
My lord, the other case is, my lord, may kindly note down if I missed to download this, print this case, my lord. It is reported 2017, 7 SEC. I'll supply a copy later on, my lord.
7 SEC.
2017, 7 SEC, 780. It's a Pawan Kumar versus State of Himachal, my lord. This talk about the evidence of a dying declaration, my lord. Because the suicide night, this talks about the suicide note, whether qualifies to be a dying declaration or not, my lord. From paragraph 22 onwards, my lord. 22 to 29, my lord. I will not take my lord's time. I'll just give the paragraph, my lord.
On what point? This one?
This is on a declaration, the dying declaration point, my lord.
Okay. Then. Yes, and
also, my lord. My lord, I will also refer to this case of Jai Bunisha's case, my lord. Jai Bunisha's case, again, my lord, this talks about the cancellation of the bail under what circumstances, my lord. Jai Bunisha, this is also paragraph 21.2 onwards, my lord. And also paragraph 14, 16, my lord, may just note down. I will, my lord.
Para 20?
Para 14, I'm sorry, we will start from para 14, my lord.
14.
Para 14, para 16.
16.
And para 20. And those are 20.1 onwards, my lord. 20. This also talks about under what circumstances bail can be cancelled, my lord. This is also the case.
Okay.
Therefore, my lord, I like to conclude my my argument, my lord. The offense involves what does the offense involves, my lord? The offense involves an abetment of suicide of a young man, my lord, caused by a senior public servants, my lord. Allegations of sexual exploitations, my lord. This is one. And this has shocked the collective conscience of the society, my lord. And this state, my lord, giving an order on the merit, my lord, finding the case, and trying to discredit the suicide note, my lord, itself is the perversity, my lord. So therefore, my lord, the learned special court, my lord, reasoning, my lord, cannot be said to be a reason satisfaction, my lord, including the absence of the prima facie material, my lord. That is one point, my lord. And my lord, the second point is that the SIT could have been given an ample opportunity to investigate, my lord. At one point of time, definitely he will get bail. Nobody could have stopped that, my lord. But at such a nascent stage, when the SIT himself is saying that we need his custodial interrogation, and on top of that, discrediting the suicide notes, my lord. This is the second perversity, my lord. And at the same time, my lord, a premature, my lord. Therefore, my lord, on these two grounds, my lord, the order granting bail, my lord, is unjustified, and also, my lord, is not rational, my lord. Therefore, my lord, I will humbly pray that my lord may be pleased to consider the materials on record. As I said, my lord, it's not for re-examining the merits, my lord. Just to find out three principles are there or not, my lord. The principle number one.
Was any perversity in the finding of the
Yes.
trial court?
Yes. So,
that is the only question.
Yes, my lord.
Arrested on 27/10. 27/10/2025. And impugn order. Impugn order is dated?
Oh, my lord, the impugned order is dated 4th of 11, my lord, 2025, my lord. 4th of 11.
Okay. Yes. Anything else?
My lord, therefore, my lord, that is the only ground, my lord. Those are the two grounds, my lord, where I would like to submit my submissions, my lord, once again, my lord, because the three principles, my lord, whether the bail is perverse, premature, and likely to thwart investigation, my lord, whether this was considered or not, in my humble submission, these three parameters were never considered, my lord. Therefore, this renders, in the absence of these three materials or the principles, renders the entire bail order, my lord, perverse, my lord. And my lord may be kindly be pleased to cancel the bail and direct the accused person to surrender, my lord. My lord, that's all. And I take liberty, my lord, if there's any rebuttal, my lord,
Yes.
Yes. My lord, I am for the respondent number 1, SIT, my lord. My lord, fact of the case is, my lord, on 23rd October, the deceased has committed suicide at his rented place at Nirjali, my lord. Located approx 6 kilometers from this area, my lord. And at that point of time, the rented owner, he lodged FIR before the police station New Delhi, my lord. So that case was registered as UD case, my lord. And my lord, the parent of the deceased person, since they were residing at Daforjo, it's approx 6 hour distance from here, my lord. So after the parent coming from the Daforjo, from the native place, at the evening time, they had lodged the FIR, my lord. Father, my informant here in my lord. So later that UD case was converted into regular case, my lord. And my lord, the allegations in the suicide note was basically, my lord, the sexual exploitation by the two officers, my lord. Firstly, the one after the surfacing of that suicide note, that one engineer one, my lord, he has committed suicide by killing himself with his licensed gun, my lord. And this one, my present accused person, he was posted at secretary, my lord, at RWD, government of this one, New Delhi, my lord, at New Delhi. So on 27, my lord, 27 October, my lord, 27 October, the present accused person was arrested, my lord, from this area, my lord, by the police. And my lord, and the same day, my lord, on the my lord, on the 27th, he was produced, my lord, produced before the court. While he was produced before the court, there was some, my lord, law and order issue in the near the premises of the court, my lord. So therefore, my lord, as my lord has asked why he was not sent to the police custody, my lord. So therefore, my lord, considering that law and order issue, the IO of the case, at that time, my lord, matter was investigated by the normal police, my lord. It was not handed over to the SIT, my lord. So the IO of the New Delhi PS case, they sought for the judicial custody, my lord, instead of police custody, sensing some law and order problem. So he was sent to the, on 27th, he was sent to the judicial custody, 14 days judicial custody, my lord. And later, my lord, the matter was handed over, considering the gravity of the offense, and the accused person is high-ranking government official. The government, state government has decided to hand over the matter to the SIT, my lord. So, my lord, matter was taken up by the SIT later. After he was sent to the judicial custody on 27, my lord. So bail order was considered on Port 11, my lord. After 6 days of his arrest, my lord. So, my lord, here, my lord, here in this case, my lord, at the time when the bail was heard before the learned session court, my lord, we, the SIT, my lord, the investigation authority has vehemently objected the bail application, my lord. As my lord has read,
all that is there on record.
Yes, my lord.
But right now, only one question is,
My lord.
He was arrested on 27/10 and then released on bail on 4/11.
Yes, ma'am.
And you yourself, you're admitting that the police never got a chance to interrogate him in custody.
My lord.
Yes, he was immediately sent to judicial custody.
Yes, my lord. My lord.
Thereafter, the SIT or the IO, whoever it may be, never even approached the trial court praying for his custody also.
They were supposed to pray, my lord. They were supposed to pray for the custody, but meanwhile, the bail was granted, my lord. But my lord, however, my lord, if read the page 15, my lord, page 15, the impugned order, my lord, page 15, para 5, my lord. They had, SIT had made some, at that point of time, my lord, SIT had made some preliminary investigation, my lord. So, my lord, that I may read, my lord. It is submitted by the additional PP appearing for the SIT that the present accused is initially registered as UD case, and I would like to skip this part. My lord, the next sentence, my lord. The case is handed over to SIT for the investigation only before 6 days, and the SIT has already started its investigation and interrogated the accused person at judicial custody after taking permissions from the court, my lord. So, by this point of time, the SIT has just, by taking the permission of the court, they had made some preliminary investigation, my lord, by interrogating this accused person, my lord. So they had some made preliminary investigation that is there, my lord. So, my lord, in this FARA 5 also, and as well as in my lord FARA 7, my lord, this was our contention before the learned session court, my lord. FARA 5 and FARA 7. Here we have vehemently objected the my lord FARA 5 and FARA 7, my lord. Here we have vehemently objected the bail application, which is also recorded in this order, my lord. Our objection was, my lord, ground of objection was because the allegation is serious in nature and the investigation is still in nascent stage, and their statement of the accused is also, there is some discrepancies in the statement of the accused person, my lord. That is also reflected in this FARA 5, my lord. So CDR has to be collected, my lord.
The question is, do you have any objection in the present application? Do you have any objection?
No, my lord, at this point of my lord, if I barely submit, my lord, because now the investigation is going on, my lord. Now the investigation is going on. But my lord, what I understand is, my lord, now, whether it's not a question if we require his the required detention, custodial integration of the accused person or not. Now we have to see, my lord, have to consider if that bail order that was granted, whether that bail order suffers on perversity or not. Yes.
That whether it's proper or not.
Yes, my lord. That present outcome, my lord, it will be, I think, my lord, to my understanding, my lord, it is immaterial, my lord, at this point of my lord. So, my lord, there is CD case diary was also called for, my lord. So there is one.
I think that may not be necessary.
Yes,
Anyway.
not be necessary. Just and one thing in this, my lord, CD, there is FSL report is there. So FSL report that I have marked.
FSL report.
Yes, my lord.
Regarding the suicide note.
Yes, suicide note, my lord. That FSL that I have marked, plague mark, my lord, that I have written in the. If my lord is having, my lord. That FSL has verified that suicide note was written by the deceased only, my lord. Yes, my lord. That is there.
Okay.
So, my lord, the main contention of the petitioner here is herein, my lord. Since the bail was considered at the very initial stage of investigation and discussed the merit of the case, therefore the bail order the bail order itself there is irrational while giving the bail order, my lord. So at this point of time, my lord, I leave to wisdom of my lord to consider whether that bail order was rightly considered or not, my lord.
Okay.
That's all, my lord.
Yes.
Petitioner, they are not on my conduct, so I have nothing to say today.
Because they are not submitting on the post bail conduct. Their main is on the legality of the
Yes, my lord.
trial court order.
My lord, I just forgot to submit one more of my citations. But there's a Puran Singh Ram that even in my grounds, my lord, these citations, my lord will find that I've taken a printout.
Okay. And this Pawan Kumar also you sent?
Yes, Pawan Kumar, I'll just send it, my lord. So that is the only thing, my lord. What is perversity?
Heard Learned Counsel for the petitioner. Mr. Your name?
P. Yobin, my lord. P. Yobin.
Also heard Learned PP.
My is SPP SIT, my lord. L Kurdu.
SIT.
SPP SIT.
So the Learned Legal Aid Counsel, Mr. Bori for the respondent number 2 or respondent number 3. Matter is disposed of. Chamber, I'll dispose today.
My lord. Obliged, Lord.
Obliged.
Lord, sure.
Yes.
Item number 7, pass-over matter. My pleasure.
Yes.
I'm sorry, my lord, when the matter was caught up, I was not there. I was in another court, my lord. So by this application, my lord, I'm challenging the my lord,
This is a motion,
motion. my lord.
motion matter.
I'm challenging the order at page 31, my lord. The cognizance order, my lord. Page 31, my lord. Is an enact proceeding, my lord. The petitioner is resident of my lord Ghaziabad, my lord. Is beyond the territorial jurisdiction of the court below, my lord. Therefore, without conducting inquiry under section 202, my lord, this cognizance was taken, my lord.
Oh,
That is
staying
my-
outside the jurisdiction
Yes,
of the
yes.
court.
Lord, that lordship will see the complaint itself is there, my lord. Page number 11, my lord. Page 12 is the address of the accused, my lord. Accused number 2. Vrindavan Enclave, Sector 12, Basundhara, Ghaziabad.
Page 11.
Page 12, my lord, of the
Page
complaint,
12.
my lord, which is in file before the court below. The address of the petitioner is the accused number 2, my lord, is
Anurag Kumar Chaudhary, such and such, Ghaziabad.
without there being 202 inquiry, my lord. This order was passed, my lord.
Heard learned counsel for the petitioner,
R.S. Mishra, my lord.
such and such. Stop. The present application under section 528 of the BNSS has been filed, praying for quashing of the order, impugn order dated 21/8/2025, passed by the learned Chief Judicial Magistrate Bomdila, West Kameng District. Stop. Spera. The case of the petitioner is that the learned Chief Judicial Magistrate Bomdila, while issuing summons to the present petitioner, has not followed the mandate of section 202 of the CRPC by
Now it is
conducting
225, my lord.
by conducting. Now it's
225, my lord.
225/225 BNSS by conducting the inquiry as required under the law, as the petitioner / accused person was a resident of Ghaziabad, UP, nah?
My lord, it is
Ghaziabad, UP, which is outside the jurisdiction of the trial court, which was outside the jurisdiction of the trial court. Yes, stop. Para, issue notice returnable within 3 weeks. The petitioner shall take steps for service on the respondent within 3 working days by inland post document. Stop.
I mean, interim period also.
And in the interim, the proceedings of where is the case number? Where is
Page
that?
31 is there, my lord.
Proceedings of NI
Case number.
case number 3/2025, pending before the Chief Judicial Magistrate Bomdilas, West Kameng District, shall remain suspended till the next returnable date. Stop. List after 3 weeks.
Much.
We will need the records also, I think.
Can court may call for?
The registry shall also call for the scanned copy of the trial court records from the court concerned.
Much obliged. Item number 12.
Sorry.
Service report in respect of R2 still awaited. How is that? You are for the petitioner.
Yes, my lord. My lord, what is happening in this case is
Informant? What happened?
it has been pending, my lord, and that's why, in place of the informant, what this honorable court can do is appoint an amicus curiae, and then we can proceed for hearing, my lord. Because ample times we have taken steps upon the respondent, number 2, and then thereafter state also have taken steps, my lord. But still then he's not to be found, my lord.
Not found.
Yes, my lord. Respondent number 2, my lord.
Third learned counsel for the petitioner, Mr. Such and Such, also heard Miss L. Haki, learned public prosecutor for the state. Stop. It appears that the petitioner has taken steps for service on the respondent number 2 on several occasions. And notice had also been issued through the OC, Police Station Tezpur, Assam, as indicated in the office note dated 11/12/2024. However, till date, the service report in respect of R2 has not been received. This criminal petition was filed on, when was it filed? Was filed on
424, my lord.
12/4.
12/4. 12/4 or 11/4?
12/4, my lord.
12/4 was filed on 12/4/2024, and the matter is kept pending till date due to inability, due to non-receipt of the service report in respect of respondent number 2. Stop. Accordingly, this court is inclined to appoint who
The list is there, Lordship.
just give the list, or you suggest someone from the list. You know better.
Okay. Zoom benang ko lang. SV darang. Zoom Valentine.
As legal aid counsel for the respondent number 2. The counsel for the petitioner shall supply a copy of the petition on the learned legal aid counsel within 3 days from today.
My lord, there's interim order, my lord, that has stayed the proceeding of the.
Within 3 days from today. Stop. The trial court records have, scanned copy of the trial court records have already been received. Accordingly, list the matter. When? After 2 weeks? After 2 weeks?
3 weeks.
After 3 weeks. So the interim order passed earlier shall continue till the next listing. The next date of listing.
Item number 13.
PCR has not been received yet. Lordship.
Not received.
Not Lordship.
The learned counsel for the appellant, Ms. Such and Such is present. Learned additional PP, Ms. L. Haki is present. The trial court records have not been received from the Sessions Court, Pasikat. So accordingly, the registry shall issue a reminder to the presiding officer, Sessions Court, Pasikat, to transmit second copy of the trial court records list after 3 weeks.
Lordship. Macam like Lordship.
Item number 16.
Yes.
Lordship, steps on respondent number 2 is still awaited, Lordship. Yes, we are unable to trace the location of the respondent number 2.
Learned counsel for the petitioner, Mr. such and such. Your
You
name?
may be allowed to take fresh step through concerned police station.
Mr. Such and such present. Stop. The notice issued to respondent number 2 had returned with a remark that the address is not found, and it was returned to sender. Stop. Thereafter, the petitioner was given some time to ascertain the proper and correct address of respondent number 2. However, when the matter is called today, the learned counsel for the petitioner submits that they are unable to ascertain the proper address of the respondent number 2, and therefore prays that he may be allowed to take steps through the jurisdictional police station. Is it?
Yeah.
Through the jurisdictional police station. Stop. Accordingly, the prayer is allowed. The petitioner shall take steps for service on the respondent number 2 through the jurisdictional police station, and thereafter submit a report after that.
Yes, we will, sir.
After serving through the OC, and thereafter submit a report before this court, list after 3 weeks.
Right.
Item number 17. May I please, Your Lordship?
Yes.
Your Lordship, this is a criminal petition filing under section 258 of BNSS, seeking for quashing the criminal proceeding, Your Lordship. Your Lordship, on last occasion, Your Lordship, this honorable court called for the TCR, Your Lordship.
TCR has not come, I think. Then what about notices? Oh, it's a joint petition.
Yes, Your Lordship.
Heard learned counsel for the petitioner, Mr. Such and such.
And Your Lordship,
Also, yeah.
on last occasion, Your Lordship, this honorable court has granted the stay. So that may be continued.
Learned counsel for the petitioner, Mr. Such and such. Staff also heard learned additional public prosecutor, Ms. L. Hagi. This court-wide order dated 7/11/2025 had called for a scanned copy of the TCR comprising the case diary, charge sheet, and other relevant documents. Stop. However, the same is yet to be received from the learned trial court. Stop. Accordingly, list after 3 weeks. In the meantime, the registry shall issue a reminder to the learned Chief Judicial Magistrate UPIA, is it? Chief Judicial Magistrate UPIA to transmit scanned copies of the trial court records. Stop. The interim order passed on 7/11/2025 shall remain in force till the next returnable date. Yes.
List after. Must have list after
3 weeks.
3 weeks.
3 weeks.
Much obliged. Item number 21 and 22.
Is it a lengthy matter?
Yes, my lord, this is exactly relating to the Contract Labor Regulation and Evaluation Act, my lord. Although there's in prima facie there's no case at all. This is a case where there's no case on the base. However, on the basis of vague complaint lodged by labor officer, cognizance has been taken without there being any prima facie. Even the act does not apply to the petitioner farm, my lord. Just to highlight, it's a very small matter, my lord. Just I'll highlight the fact background, my lord. The contract was awarded.
What about complainant?
Complainant, my lord, it's a labor officer, my lord, and he was made as a party, and it was told, my lord, I've been informed, my lord, he's got retired from the service and he's not interested now in pursuing the matter, my lord. So now
You may say that he is not interested, But as
But-
far as the court is concerned, we have to make sure that, service is complete and that he is represented.
My lord,
Mm.
that part, my lord, service has been completed, my lord.
Mm.
And one thing, my lord,
Let's see, which order says service is complete? Which order of this court? List after 4 weeks, interim order, for scan copy. According to not refresh steps, list the matter after 4 weeks. That can be listed along with this matter. And submit, I need to file representing one and two. You're representing 1 and 2, 1, 2 also.
Yes, Lordship, disconnected, Lordship, out of, Lordship.
No, what I mean is, you're representing the
I'm for one only, Lordship.
1 only.
Yes, Lordship.
Yes. Because in this order dated 13/12/2023,
Yes, Lordship.
it says that you're representing respondent 1 and 2.
Lordship, actually, by mistake, because 2 is by name, Lordship. Lordship, I have contacted Lordship by the telephonely that he has informed me that he got retired now. So he as per personally he doesn't want to pursue this matter. But as per the this concern, Lordship, this petition is concerned, his name is still there, Lordship.
That's why, and as long as it is not struck off,
Yes, Lordship.
we have to do something. Wait, on the consent place for listing, none appears for R2. Is the matter. The hearing board says such okay. Learned counsel
Well-
for the petitioner, such and such present. Stop. None appears for the respondent number 2 when the matter is called. Stop. Learned additional BP Miss L Hagi appears for the state respondent. Stop. Learned additional BP submits that she has contacted the respondent number 2 telephonically.
Yes, Lordship.
And he has stated that, and the respondent number 2 had stated that he has since retired from service and is not interested to pursue the matter
Yes, Lordship.
personally. Stop. However, since the respondent number 2 has not been struck off from the list of respondent, this court deems it proper to appoint same one, okay? That
Okay.
same counsel LLC, such and such as legal aid, as amicus for the respondent number 2. Stop. The petitioner shall supply a copy of the petition on the learned counsel. What does that name? Just tell him the name.
Uttam.
Yeah, Lordship.
That previous case.
It's, yeah, SP Darang. Lordship,
Legal aid counsel. Yes.
Lordship, there's more, Lordship, because Lordship, maybe if she
Okay,
will
then
be-
give another one.
They don't really- Who
Enjoyable.
is available here, Lordship?
Whoever is regular and who appears regularly.
M. Bagra, Lordship.
M. Bagra.
Mori
Okay.
Bagra.
Such as M. Bagra as amicus curiae for the respondent number 2. Okay. Petitioner shall supply a copy of the petition on the learned amicus, learned LSC. He is also LSC.
LSC.
Learned LSC. And thereafter, list the matter. After a week,
My lord.
after one.
Lordship.
After one.
He may be punished the copy, Lordship.
Because
Yes, I'll furnish them.
already stated to
Yes, yes, my lord. Otherwise, my lord, the record is called for, although I just.
Sure, we can take it up, no problem.
Yes.
But procedurally, we have to complete
Yes,
the,
yes,
the formalities, no? That
Yes,
is the
Lord.
only thing.
Okay.
That's all.
Yes, finish, Lodge.